I am Don Stursma. I'm on the staff of the Utilities Board, and I've been assigned by the Utilities Board to conduct this meeting in accordance with Iowa Code Section 479.5. This is the date, time, and place set for the informational meeting concerning approximately 21 miles of 8-inch diameter transmission pipeline proposed by North Iowa Community Pipeline in North County. Okay. Anyhow, the entire proposed project is approximately 36 miles long and will be located in Worth and Mitchell counties that transport natural gas. As will be discussed further in the presentation, the purpose of this meeting is to provide you with information, not to debate the merits of the project or receive evidence. The merits may be the subject of a formal hearing before the Iowa Utilities Board after the company files a petition for pipeline permit. The agenda for this meeting includes 3 areas. First, I will read a summary of the pipeline permit process and law, including the legal rights of landowners. Next, the company will present information about the proposed project, and then there will be a question and answer session. During the question and answer period, you may ask the company representatives about the project, or you can ask me about Utilities Board procedures. We do ask you to hold your questions till then because we hope most of your questions will be answered during the presentations. Now, if you want to talk about an individual piece of property, it might be better to do that one-on-one after the meeting. Now, what I'm going to do next, excuse me, change sides a little bit, is you all got a copy of this presentation, and my job is to read it to you. I know that's very well. You all should have got a copy of this presentation, and my job is to read it to you. Now, I know that's a pretty boring way to do a presentation, and you have it in front of you. It's hot in here. I'm going to go through it pretty fast. But if people are having trouble, any problems, you know, just let me know. So proceeding. In accordance with Iowa Code Section 479. Oh, wait, I'm going to do this part first. The Iowa Utilities Board. It's a 3-member commission appointed by the government. They serve staggered 6-year terms. Can't be more than up to 3, and be more than 2 from the same political party. That's pretty much true of all state boards. Confirmed by the Senate, and that's subject to be by the courts. The decision is based on evidence and within the law. That's a copy of our website. You can visit later. A lot of stuff talk about is available on our website if you want to look for more information later. The Utilities Board is what's called quasi-judicial in nature. It means they function kind of like a court, with the same kind of rules of evidence and procedure and stuff like that, although dealing with regular folks are not quite as picky as a courtroom, but kind of follows the same kind of rules. And I'll be kind of talking about some more of that as we go through this presentation. And that is the list of things we're going to be talking about. According with Iowa Code Section 479.5, the following is a summary of the pipeline permit process for the Iowa Utilities Board and the legal rights of affected landowners. Iowa Code 479 is the law governing the construction of intrastate pipelines in Iowa. The current version of the Iowa Code is the 2011 edition. A copy of Chapter 479 is attached. And the link to the laws and rules referenced in this presentation can be found on the board's webpage, which I showed you a snap of earlier. We'll first talk about the permit process. Any pipeline that operates at a pressure of over 150 pounds per square inch, or which is the transmission line as defined by the American Society of Mechanical Engineers, or in Federal Pipeline Safety Regulations at 49 CFR 192, must obtain a permit from the board prior to construction. The company seeking to build a pipeline can also request the board grant the right of eminent domain, condemnation, to obtain the right-of-way needed for a project. Iowa permitting and information requirements apply only to intrastate natural gas pipelines. Intrastate pipelines are typically those owned by utility companies regulated by the state, but it can also be other companies that own and operate their own pipelines. Interstate pipelines and multi-state pipelines which are regulated by the Federal Energy Regulatory Commission. For instance, Northwood natural gas is the interstate pipeline around here. You have the Alliance pipeline for the west, or for the east, excuse me. Those are interstate pipelines. The state doesn't regulate those. That's we're prevented by federal law from doing any permitted interstate pipelines. Now, if a proposed pipeline would be 5 miles long or longer and would operate over 150 pounds per square inch, Iowa Code Section 479.5 requires that before the company can request a permit from the board, why we're here today. The company proposing the pipeline is required to notify all parties with ownership interest in possibly affected property of this meeting. At informational meetings, a representative of the board, me, presents a summary of the legal rights of landowners, and a representative of the company explains the proposed project. The company cannot begin right-of-way negotiations with landowners until after this meeting, and cannot petition the board for a permit until at least 30 days after this meeting. Now, this informational meeting is not a hearing upon which the board will base a decision. So far, there's not even a petition before the board. The purpose of this meeting is to provide you with information relative to the proposed project, not to receive evidence on its merits. No formal record of this meeting is being made. There's no transcript, unless she's doing it, at least taping it. Anyone wishing to present evidence to the Utilities Board in favor of or opposing this project does not do so in this meeting. Public hearing on pipeline permit petitions is required by Iowa Code Section 439.7. After a proper petition is filed and review is completed, a notice is published for 2 consecutive weeks in a newspaper located in the county. The notice will identify the time, date, and place of the hearing. The hearing will be for the opportunity. That hearing will be the opportunity for interested parties to present their evidence in favor of or opposing the project. The board's decision will be based on the record created at that hearing. Now, the pipeline is over 5 miles long and would operate at over 150 pounds per square inch. Iowa Code 479.8 requires that the hearing be held at the county seat of the county located at the midpoint of the pipeline. And it looks like that's going to be early. In its proceedings, the board is not the advocate or protector of any particular landowner, landowners, or landowner party. The duty of the board is to determine whether a proposed pipeline promotes the public convenience and necessity and meets such other requirements of Iowa law or rules that may apply. The board cannot serve as a legal advisor to any party. If you believe they have a need for a personal advocate, meaning lawyer, you must obtain them at your own expense. Board proceeding, I'll clarify that to say you do not need an attorney to participate in board proceedings, to participate in hearing, to file anything with this. You don't need an attorney, but if you think you want one, feel free. Board proceedings are conducted pursuant to Iowa Code 479 and 17A and Title 199 to Iowa Administrative Code Chapter 10. Decision on whether to grant permit and or the right of eminent domain will be made by the board. The board may appoint an administrative law judge to preside over the hearing and issue a proposed decision. This proposed decision will become the final decision of the board unless it is appealed to the court without prior indication of the time limit provided in the proposed decision. When the board has decided the case, either initially or on appeal from the proposed decision, any part of the proceeding may file for a hearing within 20 days under the law section cited, and once the final decision is made, any party may appeal to the court within 30 days under the other code section cited. All case documents, including the company's filings, utility board orders, objections, and appeals, will be posted on the board's electronic filing system, and it can be viewed or downloaded from there. I'm going to talk a little bit about objections. Under Iowa Code Section 478.9, you have the right to file written objections to the proposed project with the Utilities Board if you wish to, setting forth the nature of your objections. Iowa Code Section 479.10 states that written objections may be filed at any time and not later than 5 days before the hearing. The board may but is not required to allow late objections, but it must give the company reasonable time to respond to it. Now, verbal objections, other than statements made on the record during a hearing, will not be part of the official case record. I said, if you talk to me afterwards here, if you call me on the phone, if you send me an email, anything that we might talk about between us, that's not part of the official case record before the board and can't be considered by the board in making this decision. So if you want to say something you want the board to be aware of, to consider in making its official decision on the case, you have to go through the official route to do that. And a suggested form of objection is available. There it is. There's a copy attached to the back of this form, or back of this document. By providing the form, the board is not promoting the filing of objections, and you don't need to use this form to file an objection. The forms provide a clear reference and to show the type of information an objection should include. And yes, I've had things come in the past where reading the letter, I couldn't tell which project they were talking about, couldn't tell where the property was, they didn't give me an address, and I couldn't read the signature. Can't really do a whole lot with something like that. So. Now, you have the right to appear before the board at any proceedings with or without the aid of legal counsel. At formal hearings, objectors will be given reasonable opportunity to cross-examine company witnesses and may present witnesses on their own behalf. The burden is on the company to prove the necessary elements of the petition. Board hearings or proceedings are quasi-judicial in nature. That means they're comparable to corporate proceedings and follow similar rules of testimony, cross-examination, and presentation of evidence. The person presiding over the hearing will assist participants unfamiliar with such proceedings, but cannot assist them with the presentation of the case. Anyone who files an objection will presume to be a party. If another party challenges the objector's right to be a party, the objector will be required to demonstrate some right or interest that might be affected by the granting of a permit. The challenge to the right of the objector to be a party can be made at any time, including at the hearing itself. The board strongly prefers that objection be filed using our electronic filing system. However, we will accept written objections sent by mail. Although that which is sent by mail will be copied and posted in our electronic filing system. So, yeah, anything you send us is a matter of public record. Anybody can look at it. Talk about right away a little bit. To locate a pipeline on private property, the company must obtain the necessary rights from the landowner or owners. The legal document providing such rights is called an easement. An easement may be a voluntary easement, which is when the landowner agrees to sign after negotiating with the company, or it can be obtained through condemnation or eminent domain. Generally speaking, an easement is an acquired privilege of the company for the use of the property. The landowner retains ownership. The use of the easement area is restricted by conditions set forth in the easement or by law. The rights sought by the company will be similar whether obtained by voluntary easement or by eminent domain. The board does not supervise or control negotiations for the purchase or acquisition of voluntary right-of-way easements. Once this informational meeting is completed, negotiations are strictly between you and the company, either with or without the use of private counsel. And that includes money. We have nothing to say about what an easement's worth. That's strictly between you and the company. Or if you can't agree, you could theoretically go to condemnation, although it's safe to say that nobody wants to do that. Landowners should carefully read the form of easement provided by the company and be thoroughly aware of the rights the company seeks. The landowner has the right to negotiate with the company over the terms of the easement. Translation, they put an easement form in front of you. You don't have to sign it the way it is. You can talk to them about, something different changes. Easements are negotiable. Not only the money, but also the terms of it. If future installation of drain tile or soil conservation practices and structures on a property is contemplated, this information needs to be provided to the company in writing prior to securing of an easement. If plans are defined by a qualified technician showing this intended work provided to the company in advance, board rules require that the pipeline must be installed in a manner that avoids interference with those plans. Now you might think, what is a qualified technician? Well, it used to be the Soil Conservation Service with the old days would lay out tiling plans for you. I don't know if their descendants do that today or not. The thing is, you need something that's accurate enough that they can put it on their construction maps, put it on the records and stuff like that, just saying, well, I'm thinking about putting some tile over there, got to be something a little bit more accurate than that, something they can actually measure, rely on, and make the necessary accommodations to put the pipeline in. If you decide to sign a voluntary easement, you have a limited time, for a limited time, the right under Iowa Code Section 47934 to cancel the agreement. Cancellation must be certified mail if attorneys requested and mailed to the company's principal place of business. The company must receive the cancellation within 7 days, excluding Saturday and Sunday.
There you go.
Okay, that's it. On now?
Nope.
Okay. Is it on now? No.
Hold the wire up.
Hold the wire up? Like that? Ooh. Looks like I may have to hold this button down to get this thing to work. Is it working now? No. Why doesn't it work on my hair? Okay, you may have to hold this button down. I have to hold it down long enough to kick it back on. If you decide to sign a voluntary easement, okay, I went that far. company must receive the cancellation in 7 days, excluding Saturday and Sunday of the date they're going to sign. The company must inform you in writing of your right to cancel and provide you with a form and duplicate for the notice of cancellation. The right of cancellation is exercised only once. If you have not allowed company surveys on your property up to this time, Iowa Code Section 43930 gives the company the right to enter upon land after this informational meeting for making land surveys to determine the direction of the pipelines. If permission has not been obtained voluntarily, the company must get the land under 10 days written notice by restricted certified mail of its intent, after which it may enter the land. The entry for authorized surveys is not trespass and may be aided by injunction. The company must pay for any damages incurred during the entry of the survey. If a pipeline right-of-way is wholly abandoned for pipeline purposes by relocation of the pipeline, is not used or operated for 5 consecutive years, or if construction has begun but ceases and not resumed for 5 years, the right-of-way may revert to the current landowner. The process for effecting reversion for non-use right-of-way is in Iowa Code Section 47948. So this doesn't happen automatically. If you believe a pipeline is abandoned, the easement doesn't just revert. There's actually a legal process you have to go through to get off the books. I'll talk about eminent domain. If a company cannot obtain the rights it seeks by voluntary easement, it may petition the board for authority to take those rights by eminent domain or condemnation. The request for eminent domain may accompany the petition for permit and be considered the same procedure. Under federal and state law, actually its constitution, private property cannot be taken for public use without A, an easement for the public use, and B, just compensation. Under Iowa Code Section 479, the board determines whether the company has shown a need to serve public use by meeting the public convenience and necessity test. As a matter of just compensation of the property rights taken by eminent domain is not determined by the board. That's determined by a compensation commission appointed from your county under Iowa Code Chapter 16. At this time, the company does not have the right of eminent domain. That is, it does not have the power of condemnation at this time. The right of eminent domain may only be granted by the board after a public hearing on the eminent domain request. Iowa Code Section 479.5 requires that at informational meetings, the board representative distribute and review a statement of property owner's rights prepared by the Iowa Attorney General, and these have been adopted as administrative rules in 61 Iowa Administrative Code Chapter 34. I believe that's the next slide. No, it's not. We changed the presentation a while back, and then we're slipping on what's in it. But a copy of this is attached to you at the back of your handout material. And I must say this part of the presentation is a little bit awkward because the legislature did direct the Attorney General to come up with a statement of landowners' rights when condemnation is used. But it's designed for condemnation of property ownership, not the acquisition of an easement. So there's parts of it that don't really apply to an easement. But the law still requires that we present these rules at these public information meetings. Now, in these rules, an acquiring agency is not limited to government agencies. It can include private entities that by law have the right of eminent domain. The rules primarily address acquisition of property ownership, but some provisions apply to condemnation of easements. Also, the Attorney General has not updated these rules since 1999, and some of the code sections are out of date. We've taken the liberty of marking up a copy of these rules to show the correct citations. And if you'll please turn to the attached copy, we will quickly review them. There are 12 property rights set forth in Chapter 34. These rights pertain to owners of record who may have property acquired by condemnation. Condemnation is a process for taking private property for public use of the power of eminent domain. If an easement on your property would be condemned, the first statement, right on the statement number 1, would apply. The Iowa Constitution guarantees the right to just compensation for taking the property. Rights 5, 6, and 10 can also apply to property condemned for utility easement. These rights address the procedures and condemnation proceedings taken by the court appointed compensation commission determining the amount to be paid to landowner. Other rights listed may apply only if property ownership is to be obtained by condemnation. An easement is the right of use over the property of another, but it does not transfer ownership. So there's other provisions, if you're not talking about transfer of ownership, the provisions dealing with transfer of ownership don't apply, obviously. The rights set out in Chapter 34 are not a full and complete list or explanation of the landowner's rights under condemnation law. And for a more thorough presentation of owner's rights, you should refer directly to the Iowa Code sections or contact an attorney of your choice. Next, we're going to talk about damages. I said when I talk about damages here, sometimes the payment for the easement is called the damage payment. That's not what we're talking about here. Right now we're talking about compensation for property damage during the course of the pipeline project. In addition to the payment for easement rights, the company is in addition required by the law section cited to pay for actual property damage caused by construction and maintaining the pipeline. Payment for damages, including those incurred before, during, after construction, is different from the payment for easement. However, the easement may include provisions covering the determination of payment of damages. We talked about this earlier about how easement is negotiable. If you want to make sure that you get the compensation that you think is fair for something that you think is going to be affected by the project, you can have something easement about that. Now, in this context, damages means compensation for adverse physical impacts to land, crops, livestock, and other personal property. The law is mainly oriented towards damage to agricultural lands and provides a list of primarily agricultural damages that are specifically eligible for compensation. However, those are not the only damages that may be claimed. It's a list of kind of examples. It's not an all-inclusive or exclusive list. Any type of physical damage to agricultural or urban property is subject to compensation. And if a tenant is the owner of the crops, livestock, or other affected property, the tenant would also be eligible for damage compensation. The damage settlement may include an allowance for temporary reduction in crop yield in the disturbed area. If in future years the owner believes the settlement made for future crop efficiency was inadequate, the law allows renegotiation. The landowner must notify the company in writing 14 days before harvest each year to assess the crop efficiency. So in other words, the first year or two after construction goes in, you make some kind of settlement for anticipated reduction yield when the time it's going to take the land to recover. If you go out there a couple of years later and say, hey, I didn't get enough, you can go to the company and say, I think I'm entitled to additional crop efficiency payment. But you got to give them a chance to look at it first. You can't go out there and pick the corn or whatever, and then go in and tell them, I think I need more money for that strip. They get a chance to look at it and make their own assessment. Now, in the context of damages, the term owner may refer to the tenant of the land if the tenant is the owner, crops, or livestock are affected. That is actually a good look at it in this form, but I think it's worth to mention it twice. The company must provide you with a written statement on how damages resulting from pipeline construction will be determined and paid. You have the right to negotiate with the company for more specific or additional terms in that statement if desired. We talked about having reasons to easement on damages. There's also a separate written statement on the standard provisions on how damages will be paid that they'll also give you. And again, that is negotiable if you think you have things that it doesn't cover. Under board rules, the pipeline company must designate a point of contact for landowner inquiries or claims. The information must provide a name, address, and toll-free telephone number. This information must be provided in writing prior to the construction to all landowners of property that would be disturbed by construction. When construction is completed, a point of contact shall remain available for at least 1 year for all landowners and for individual landowners until the claims are settled. And damage settlements are, like the names, not decided by the board, but are subject to negotiation between the owner and the company. The easement or other written agreement between the landowner and company may provide that damage amount be determined by an arbitrator and the procedures set forth in the law section cited. Now, under the way the law is written, this option is available only to the landowners, not the tenants. If the parties cannot agree on a settlement and no other means of resolving disputes has been agreed to, the landowner can may petition the county board of supervisors to have the damages determined by a compensation commission. The petition was filed between 75 and 100 days after completion of the installation of the pipeline. This compensation commission would be similar to, but acting separately from, the commission established for condemnation procedures. If the award of the compensation commission is more than 110% of the company's final offer for damages, the company must pay for the cost of the assessment by the commissioners plus reasonable attorney fees and costs incurred by the owner as determined by the commissioners. If the award is 110% of the company's final offer, then the landowner must pay the fees and costs incurred by the pipeline company. So if you think you're not getting the first settlement on damages and want to go to this compensation commission to deal with it, you better be darn sure. Otherwise, sure that you're right. Otherwise, it could end up costing you. Iowa Code Section 6B52, entitled Renegotiation of Damages, provides that, and I'm going to take a deep breath and read this here, because this is out of the law and this is what the legislature wrote. Whenever property or interest therein has been taken by condemnation or has been purchased for public use and a settlement for construction or maintenance damages has been thereafter entered into pursuant to said condemnation or purchase, the owner shall have 5 years from the date of said settlement to renegotiate construction or maintenance damages not apparent at the time of said settlement. The condemner or purchaser shall give notice to the owner of such right of renegotiation at the time said settlement is entered into. So basically, if you settle for damages and you find additional damages later and it's something you couldn't really have known at the time that you made your damage settlement, you can go back and make an additional claim on it. Damage to tile lines is one of the more common things that comes under that unknown damage provision. If a company has previously constructed a pipeline on a property, which doesn't really apply here, but this is the right, Iowa Code Section 43942 forbids construction of another pipeline under that same easement if there is an outstanding unpaid damage claim made from previous construction. This does not apply for claims in the process of being settled through arbitration or litigation. Also, this section to apply except for claims for damage to drain tile and future crop deficiency. Landowners and tenants must have submitted written claims for the damages to the pipeline company within 1 year after final payment. Iowa Code Section 42925 gives the company the right of reasonable access to its pipelines for the purpose of constructing, operating, maintaining, and locating. The company must pay the owner of the land and crop for all damages resulting from such entry in action. The law allows execution of agreements to cover such situations between the owner of the land or crops and the company. So if the company needs to access the pipeline to repairs, remedial work, whatever, and like has to cut down some crops to get to it, you get paid for that. Iowa Code Chapter 480 requires Iowa one-call system be called before excavating is done. Excavation does not include normal farming and gardening practices, but would include tiling and construction of erosion control structures. I don't know if you've noticed the news lately, but in the last month we've had 2 major pipeline hits by tiling crews, neither of which have called Iowa one call to have the pipelines marked. And we got 5 people that are very, very lucky to be alive. In one case, the tile plow got blown over their heads and landed in front of them as they were running. Very lucky people there. The law defines normal farming practices as tillage up to 15 inches deep. The comments will be made at least 48 hours before excavation begins, including Saturday, Sundays, and the holidays. The owners of any underground utilities in the area, including pipeline companies, must mark the location of the lines within 48 hours, or must notify you that its lines are not within the area where excavation is proposed. The one-call number is 1-800-292-8989, or you can just call 811. It's actually got its own 3-digit number. There is no call for the charge for having the line marked. In addition to possible hazards, failure to call members of the landowner liable for damages to the utility. We're not talking just pipelines here. You cut a fiber optic line, you really probably not going to really be responsible for paying for getting that thing fixed. Last section, almost done. Agricultural land restoration inspectors and camp inspectors. Iowa Code Section 47929 requires that the Utilities Board adopt rules establishing standards for the restoration of agricultural lands during and after pipeline construction. Those rules are found at 199 Iowa Administrative Code Chapter 9. During construction, these regulations will be enforced by inspectors hired by the county, not by the Iowa Utilities Board. Iowa Code Section 47929 also requires that when a petition for pipeline permit is filed, it must include a land restoration plan showing how the requirements of the land restoration laws and rules will be met. The board will consider this plan as part of the proceeding on board the grant pipeline permit, and the company must provide affected landowners with a copy of this plan prior to starting construction. Iowa Code Section 47929 allows landowners to negotiate an independent land restoration agreement with provisions different from those of the board rules or the land restoration plan, provided they are not inconsistent with the rules. Such agreements may be part of the easement or can be a separate agreement, but they must be in writing and a copy provided to the county inspector. So if you want some additional terms and conditions for land restoration, agreed to with you and the company, you have every right to do that. But it has to be in writing, and you have to give a copy to the county inspector. Because the county inspector will enforce these private agreements, but obviously they have to know about them, and they may not know about them if you don't tell them you have them. So keep that in mind. The company shall allow landowners and county inspectors to view the proposed center line of the pipeline before commencing construction operations to ensure that construction takes place in its proper location. Basically, it's going where you thought it was going to go. If it's going someplace different where you thought it was going to go, you may want to talk about it with the company. The county inspector may temporarily halt construction if construction is not in compliance with the land restoration rules, the land restoration plan, or an independent agreement on land restoration line location, until the inspector consults with the supervisory personnel of the pipeline company. Any special provisions in those areas, if any special provisions are made during easement negotiations, make sure the county inspector is aware of them before construction begins on your land. Kind of duplicates what I just said, but again, I think it's an important point. Now, attached to this presentation is a summary of events entitled Appendix A. This will not be read, but it provided me an overview of the process and the sequence of what we're doing. Excuse me. Did you grab me that piece of paper?
Is that one right there? Yes.
Can't walk without a skirt. I now call on North Iowa Community Growth Pipeline to introduce the personnel and make their presentation. And again, we do ask that you hold any questions you may have until completion of their presentation. And we have not rehearsed how this is going to work. So I just leave it up to North Iowa to make their case.
My name is Rick Schwark. I'm the CEO of Absolute Energy. I'm just going to introduce the people that are associated with the project and turn it over to Tom. We've got Justin representing Black Hills Energy, and I'm sorry I don't remember Dave Howe, and Dennis May with Worth County. Brad, if you raise your hand, he's our CFO for Absolute. Greg Goppenroot, treasurer. Tom with legal counsel. Stan Watt. And Kenny Akers. And Dennis Fannin up there with Osage Municipal Utilities. With that, I'll turn it over to you, Tom.
My comments are going to be very brief. I just want to give you a little background on the project. My age and need glasses to do that. And then turn it back over to Don, and we'll have questions from anybody in the audience, and we'll try to answer your questions. We have engineering experts here that can answer technical questions and respond to anything. North Iowa Community Growth Pipeline is an Iowa limited liability company that has been formed for the purposes of constructing this approximately 37-mile pipeline that runs on the Iowa side of the Iowa-Minnesota border from Worth County east and then south into St. Answer. The LLC is proposed to have 4 members, 2 counties, a municipal utility, and then the Rick's company, Absolute Energy. The purpose of the pipeline really is multiple. Both Worth and Mitchell County are looking for a more consistent economic source of natural gas for economic development. We are planning on using the pipeline as a source for natural gas for the Diamond Joe Casino, which now runs off propane. We're also planning on using the pipeline as a source for natural gas for Absolute Energy's ethanol plant, and then the Osage Municipal Utility intends to use the pipeline as a source of natural gas for its utility. It will also then supply natural gas to St. Answer. Don read you the process that we have to go through at this point. As he indicated, this is a public meeting, not a public hearing. We have not filed a petition with the Iowa Utilities Board at this point, and so this is for informational purposes only. And with that, I'm going to turn it back to Don, but we are all available to answer any questions you have about the North Iowa Community Growth Pipeline Group, and we also have the Black Hills engineering folks here who can answer questions from a technical standpoint.
Anybody else from North Iowa talk? Gone. I guess we'll open for questions. Not for questions. I'm not standing up here by myself. Some of you guys from North Iowa are going to have to answer questions if you put about the project. Sir?
How deep will it be?
Excuse me, I can't hear you.
How deep will the pipe be?
How deep?
In agricultural land, there's a state rule that says it must be at least 48 inches deep, or it needs to be to get under toplands. And that's not a rule that's actually deeper than the federal standards that control most of the rules on pipeline construction.
Is that the top or bottom?
Top, 48 inches of cover.
Okay.
How far from the center of the road will it generally be located?
That is North Iowa's call on exactly where they're going to put the ditch, where they're going to put it on private property next to the ditch. I don't know what they're thinking.
It basically is our intention to try to go down as much of the county right-of-ways as possible. And so we're really looking at here in Worth County, right on the state line, there's about 2.5 miles that does not have any county right-of-way. And so this would be, in Worth County, the only private property that right now we would be contemplating on trying to get some easements from. And with those 2.5 miles, if any of you are landowners there, we'd like to be able, if you would, to have a few minutes to visit with you after this meeting.
What section?
I mean, right, we're on the state line, so whatever.
Where on the state line? Said 2.5 miles.
We're on the state line.
East and west of 65.
Yeah. It appears to be in Grove Townships, Township 8 and 7, and Heartland, Township 12.
Probably some places, I drove this yesterday and looked at some places probably are going to need private easements, like we're across the interstate. I'm not sure the way that embankment slopes there, there's going to be room at the base of that embankment to put that on road right away that getting on private property. And there's a piece, I think this piece is in Mitchell County, where it looks like that ditch is being used for as an organized drainage. It's something a little bit more of the ordinary road ditch. So it's like it's being served as a drainage ditch that you might not be able to get into either. So there's places, I would just say there's places that there won't need private property easements, but as right now you probably haven't identified all those locations. Oh, I'm not out of line by saying that.
Yep.
Bodies of water at such as creeks and rivers, are you going to go over them or under them?
My understanding is that we would burrow underneath those.
Could you repeat what the questions are, because we can't hear what all the questions are as they ask, please?
The last question was bodies of water, would we go over or underneath?
This 50-foot permanent easement, where does that start? Does that start right on the state line?
Repeat the question. Couldn't hear it.
Question was 50-foot easement, where does that start? Does it start in the middle of the road, start at the end of the road? Again, I'm just repeating the question, I don't know.
I would assume that would be starting at the, you say right at the middle of the road, the state line.
Any damage to pavements, is that taxable income to us?
That I had no idea.
Yeah, damage to pavements.
What other routes are you considering?
Basically, the routes, the question was what other routes? Basically, all of the routes were shown in both the newspaper and mailed to you. These were the only routes that right now we are considering.
What time frame? When will they be starting construction? Will it be after the fall crops are out, preferably, or?
The question is what time frame? Right now, we really have no time frame. What is happening right now is we are trying to take a look to see if this is a feasible operation. Basically, we have really two possibilities. One is that we need to bring some gas into Osage that we could come in from the south. The problem with coming in from the south going to Osage is the new plant that's coming to Osage, we could provide adequate gas at this time if that plant, and it looks like they very well might be willing to wanting to double their capacity in the future. They are actually building in possible expansion. We would not be able to supply enough gas. Worth County also has gas issues, and by coming on this northern route, and if we're able to work with Worth County and with Absolute Energy, basically we're going to solve a lot of long-term problems. One of the things that most of you really desire is to keep our youth in the area, try to maintain economic development, and without additional natural gas, we can't do this. So we've been taking a real hard look at what all of the possibilities are. This really is the best possibility for all concerned, and this is why it's a unique opportunity. I don't think a public-private partnership has probably ever been tried here in Iowa. Maybe it has, but it's rather a unique opportunity anyway for us to do economic development and for the future of both Worth County and Mitchell County.
It is the first one of this nature done here.
The comment was made that they wanted the pipeline to go down to the casino. I don't see that on the map here, but wouldn't it make more sense to just come down to the casino and go 105 then instead of going to the casino?
This part of our is not part of any possible casino. That would have to be another project at another time. But this gives the opportunity to go down to casino.
Basically puts a T in a state line.
Basically, like Supervisor Abrams says, we can put a T at the state line, so it gives an opportunity later on.
Why not locate that line centrally in the county?
I'm sorry?
Why not locate that line centrally in the county to go across, rather than going up on the state line?
That's a decision again by the Worth County Board of Supervisors.
Did I understand you right that the company may not need to purchase easements if the pipeline runs along the road?
If we can adequately put the pipeline in the county right away without disturbing your property, no, we would not need any easements, which we would be trying to look at. hopefully that on any county right of way, we would not be infringing on private property. So.
I can imagine the power lines that run through there, they must have an easement already, don't they? Power lines run through along the state line, the south side.
Power lines, do they have?
They would have a, yes.
Their own easement, so you'd be going between that easement and the road, saying down the road.
That would be a possibility.
So if you purchase an easement, you could come along and put more pipelines in the future without any consent to that?
That is a legal question. I would assume it depends on how the easement was written.
Yes, that's, if you want to make sure that you're only granting easement for one pipeline, make sure the easement says you're granting easement for this pipeline and nothing else in the future. That actually has been an issue in the past with some easements that were written in like the 1930s where they pretty much gave a right to install pipelines, and later on, I think landowners found out that that meant a little bit more than they bargained for when they signed the easement.
If a person would have plans, or even not have plans, but would end up building a building or a barn over the pipeline 10 years after it's laid, how would that interfere with the company? Would that work? Or would we have to let them know by the time they lay the pipe? Or how would we change our mind after? Is that?
Again, I think that's a legal question that you'd have to.
Well, again, we don't control the easements, but if it's a normal easement, a condition of the easement is going to be that you don't build a building over the pipeline. That's normally one of the rights that's acquired as part of the easement.
So if you take trees out of a person's windbreak, would the person be able to plant trees back out over the pipeline, or that would probably be prohibited also?
Take out trees.
Where's our Black Hills strip?
That would be part of your reason. You'd be suggested not to, but again, if it's not public right away, so it wouldn't be an issue for most part. That would be part of the conditions that you would have if you live
Well, if you're concerned about trees, that's something that could be written into the easement. You do the easement. It's something that can be negotiated as part of your payment of damages. There's a number of ways that you can go about making sure that your compensation for any damage caused by loss of trees.
Also with trees, it is possible that the pipeline could be bored underneath if trees were special trees that you absolutely needed to save. So we could be able to work with the landowner on something like that.
Talk about trees, and we give you another example too. I'll talk about the ways of negotiating things. If they have to take a tree out and you want the wood, make sure that that's part of your agreement.
Does the code say anything about historical landmarks or preservation of the road?
No, it doesn't, although if that information is brought to the board's attention, it could influence their decision.
Historic preservation.
Are we done?
If nobody has further questions, okay, I'm sorry.
In your presentation that you had here from the board, it says that the board is to determine whether the proposed pipeline promotes public convenience and necessity. Define public convenience and necessity.
Define public convenience and necessity.
That's one of those terms that's more or less can't be defined easily because it's based on a multitude of factors and tons of court decisions set based on what's reasonable for it. Now, I've got to remember, I'm an engineer, not an attorney. But it's a case-by-case thing, but basically that the company has to make a case to get this license, and especially the right of eminent domain, that this is a good project, it's beneficial to the area, the people as a whole. It's, that serves kind of a public purpose, even if it's a private entity doing it. That's the kind of case that has to be made.
So will consideration be made where the state line route has a lot of residences on it?
Excuse me?
The state line has a lot of residents along that that are located close to the road, within say 300 feet. Is the board going to look at that being, you know, not the best choice? Or do we have to raise issues ourselves and try to get with the route?
The fact that there's houses near a route like this is not a disqualifier. If the board would be concerned about those ways to alleviate that concern. When I drove it yesterday, I only saw a few houses that were within I would consider, you know, close. And for whatever reason, it seems like most of the houses are on the Minnesota side. But the board will certainly consider people's concerns in that area, but it's not a disqualifier.
So safety isn't necessarily a top priority. We're another route to farmland, get away from residents.
Safety is a concern of the board will address. But safety does not mean it can't be anywhere near buildings. I mean, it's certainly not uncommon to have buildings near a pipeline. So it's not an automatic disqualifier.
If you would run into problems like you were referring to, would you consider going on the Minnesota side, or are you restricted to the Iowa side?
I have nothing to say about what happens in Minnesota.
No, we want to keep this on the Iowa side, otherwise it becomes an interstate pipeline.
Well, the properties along this route, say you have a farm there, will you have access, will you be able to buy natural gas off that pipeline, say for your farm business and your residents?
I believe the answer is no, basically because this would be a high-pressure pipeline, and it takes, maybe Black Hills can really answer that better than I, but what would be required in order to?
There would certainly be an expense. I would just say that's an agreement between the LLC and the customer, is what I would say. There are locations out there that people have service off transmission.
Okay. Possible, but maybe not.
Could you repeat his answer?
Big question is, we've got 5 years to try and recoup extra expenses. My question is, what if the LLC is dissolved within the first 2 years?
They're required to, part of one of the things they have to do is show proof of financial security and ability to pay damages, and now they should know this $250,000, I believe. So if that, as part of our permit decision, one of the showings they have to make is they do have money, hopefully money that somehow saved in reserve that can be used to pay damages.
If there are no other questions, if we do have landowners that we would have to actually obtain easements from, we would like to be able to visit with you a few minutes here at the end. So thank you all for coming, and we'll be sticking around.
Usually after the auctioneer, the crowd can do a going on speech. With no further questions, then the requirements of Iowa Code Section 479.5 are satisfied by the presentation and discussion was completed. The company may now legally negotiate with you for an easement or other property interest. And that is being adjourned. Please turn off cell phones. Don't put them on vibrate. Calls. I did have one where I told people that my phone rang here. Okay, it is 2 o'clock. My name is Don Stursma. I'm on staff of the Iowa Utilities Board.
We can't hear you back
You're gonna have to speak up, bud.
I'm gonna walk down here.
I can't hear you.
Yeah.
If I'm not talking loud enough, you know, let me know. I'm Don Stursma. I'm on the staff of the Iowa Utilities Board. And I've been assigned by the Utilities Board to conduct this meeting in accordance with Iowa Code Section 479.25. We did not rehearse this, so I don't know what we're going to do. But I do ask that you please try and hold your presentations to questions until after completion of the presentation.
I'm Rick Schwark. I'm CEO of Absolute Energy. I'm going to start with introductions. Anyone representing Mitchell County, you want to stand, please? Introduce yourself, Stan.
Yourself today.
Stan Watt. Anybody from Worth County here right now?
Ken Avery, Worth County Supervisor.
Dennis May, Worth County Supervisor.
Anybody from Absolute? Want to stand, please? Steve, want to introduce yourself?
Steve Neely, Director at Absolute Energy.
Bradley Richardson, CFO.
Kim Alvey, Plant Manager.
Very good. Osage Municipal Utilities?
Dennis Fannin.
Thank you.
Good. I'm Tom Stanbury. I'm an attorney in Des Moines, and I represent the North Iowa Community Growth Pipeline Group. And what I'm going to do is give you a brief overview of the pipeline, talk about a few particular aspects of what Don already talked about in the easement process and the negotiations if the project goes forward. And then I'm going to stand up here and take questions, and a variety of people will be able to answer your questions. Everything from a technical nature, if you've got technical questions, the questions about restoring fence rows and windrows, and how the project actually comes to being. So North Iowa is an Iowa limited liability company, and it will be made up of 4 different entities: Absolute Energy, Osage Municipal Utilities, Worth County, and Mitchell County. And their proposal, as you've heard, is to put in a 36-mile natural gas pipeline. I know you can't see this all the way back in the back, but here's a little diagram, and I'll leave this up the front table so if you want to take a look at it. Essentially, it stretches along the Iowa-Minnesota border from just west of I-35, and then we'll come over to about 218 and drop down basically due south into Osage. The pipeline is being built by this group for really 4 purposes. Provide a reliable source of natural gas to both Mitchell and Worth County for economic development purposes, provide natural gas and a reliable economic source to Absolute Energy at their ethanol plant, and ultimately it may provide natural gas to the Diamond Joe Casino, although that's later on in a later phase of the project, which now is running off of propane. We're in the very early phases of organization. The LLC has been organized. The filings have not been made with the Utilities Board. This early public meeting is just that. It's a public meeting to answer questions. As Don said, this is not a public hearing. We're not here to negotiate, but we're here to answer a lot of questions. One of the items that he raised in his discussion about the process is the easement process. And for those of you, and I suspect everyone in here is probably familiar with easements, for those of you who aren't familiar with an easement is a legal contract between 2 parties that gives one party the right to do something on the other party's land. So if I enter into an easement agreement with you, I'm going to pay you some amount of money. I'm going to talk in a minute about how you arrive at that amount of money. And in exchange for that, you're going to give me the right to come on your land and do certain things. It might be, in this case, the right to put in a natural gas pipeline below ground on the property. The easement is something that you negotiate between, in the case we're talking about today, North Iowa Community Growth and yourself. And you negotiate everything from the price of the easement Price of an easement is normally based on the price of the property and then a percentage of the price of that property. It's in many cases, the price of an easement is a lot like negotiating the price to purchase some land. You negotiate the price, you negotiate the terms, what North Iowa can do, install a pipeline, what North Iowa must do, restore your land back to the way it was before they put the pipeline in, and then any ongoing responsibilities that North Iowa might have with respect to that easement, and what you can do with respect to the ground that's now above the pipeline. So for example, can you build a building on it? Can you plant a tree on it? Can you put a fence on top of it? All of these things are going to be negotiated in the terms of the easement, and the easements will be fairly uniform from property owner to property owner, so there's not going to be a lot of difference, so that everyone's operating under generally the same terms. And that's how the easement is going to work. There's some other things that I know will pop up, some of the things that Don mentioned that we want to address, but why don't we start just taking questions now, and just a second.
Why don't we give them just a little bit of background on why we've got to this point, because I think a lot of people are curious on why we're trying to formulate this LLC. Why doesn't just private enterprise, somebody like Northern Natural, do it? And basically, what has transpired is that we have a biochemical company coming to Osage. And this biochemical company is going to need a lot of gas. And one of the things that the company failed to look at when they first decided to come to Osage, or actually Mitchell County, is they were real concerned about their the amount of electricity that would be available. They forgot to ask about natural gas. And right now, we do not have enough gas in the county to have them operate 24/7, 365. It is possible that what they call the Fredericksburg Loop could be upgraded at a sizable cost, and gas would be adequate so they could operate to begin with at 24/7, 365. Part of the plans that this company has is this company, when they're building their building, they have room for expansion. It's my understanding that the Fredericksburg Loop would not be able to provide them enough gas to double their capacity. So this is a concern for all of us here in Mitchell County. Then we took a look at understanding that Absolute Energy wouldn't necessarily mind a second supplier of natural gas. And it had to do with the cost of the raw gas. And so basically we tried to take a look at what all of our options were. One of the problems that occurs is if somebody like Northern Natural was to build a line, they cannot by law build in excess capacity. We here in Mitchell County, and I think I can speak for Worth County, we're trying to look for the future, economic development. We're trying to figure out how to keep some of our youth here, how to get some more industry here, how to try to utilize our schools better, how to keep our main streets going. And if Northern Natural was to try to build this line without excess capacity, basically what that means is if a company came here to Mitchell County and they ask, do you have natural gas, enough natural gas that we can locate our company here? Right now Northern, because Northern does not allow excess capacity, would have to say no. Most of the time those companies then are going to look someplace else. They want to be guaranteed right away that we have excess capacity. And so This is why Mitchell County is getting involved. This is why Worth County is getting involved. Because we can build excess capacity into the system and we can control the system. Also, by having some ownership, we would also have revenues coming from this line. And so this can be a revenue producer and also, like I say, helping us on economic development. One of the things trying to work on this project at the beginning, I contacted the Iowa DOT, the individual at Mason City, and I asked about running gas lines by not only the interstate line, Interstate 35, also about US Highway 65 and US Highway 218. The individual at Mason City basically said it was a problem to run longitudinally, whatever that word is, along Interstate 35, but he did not see a problem on US 218. I come to find out a couple of weeks ago that is a problem. And so when we first proposed this line, coming to Absolute, and then following a little bit of 218, and then cutting on over to Glass Avenue, that no longer is an option. We're going to have to be able to stay right on the state line over to Glass Avenue and then come straight south. So any of you folks that were sitting on Highway 218, that is not an option any longer for us, is what the state of Iowa DOT has basically explained to us. So I want to make that perfectly clear today. So with that, I think that pretty well should give you a little bit of background why we're doing what we're doing, or why we're proposing what we're doing. And, any questions?
Can I do that? Anytime you get government involved in something, there's usually a problem. And the individuals are the ones who suffer. Okay, the counties are going to get revenue out of this, so it's ultimately important for them to get this put in. So if you have an individual landowner that's got a problem or a grievance, he's going to be fighting the county and the company and their attorneys. Am I right? Because now you're going to stand up and want this thing, and that man or woman wants their right, but they're going to fight government here.
Not necessarily. You're assuming that we cannot just that we have a problem that cannot be solved.
I'm just saying that there's a real problem between an issue. The individual's going to end up with eminent domain, and the county's going to stand out in front. Just because they're part owner, they're always going to end up on the top end.
Not necessarily.
I'd like you to prove that. Because I've had a lot of go-around, and I've been in government for over 30 years. I know how that works. I'm hoping there's no issue.
Yes.
So you just made a statement that if you live on 218, the property is off the route.
That is
but
correct.
This is not an official capacity meeting. So is there some point that can change? Or if it does change, are you then required by law, because you made a statement today that 218 properties are off that line, that we would have to re-notify of the intent to go on 218 once again?
You want to address that?
Well, first of all, my understanding is it's DOT has what they call their utility. The DOT has what's called their utility accommodation policy for allowing utilities in road right of way. And normally they do not allow pipelines over 150 pounds pressure in road right of way. I don't know if there's a way around that or not, but it's state road right. But that's pretty much their.
They don't allow pipelines at 150 pounds for what?
Pounds per square inch pressure.
But what was the next word you said?
Okay, they do not allow pipelines operating at over 150 pounds in road right of way.
In road right of way.
Right.
State road right away.
State road right of way. That's state road. That's not county.
So you're going off.
They can cross them, but you can't go longitudinally.
You can't parallel with the road.
Yeah.
Right, but you didn't answer the question.
Sorry, the second part of the question had to do with whether there would be another informational meeting. And the answer is an informational meeting is required if more than 5 miles of private property might be affected. So whether another informational meeting is required by law would depend on whether the total route change involved more than 5 miles of other people.
What about notifications if it changed? Back when you figure out a way to make a run on the
Well, don't we have to, this is just the first notification. If we put in for an actual application, we have to have an actual route. And at that time, that has to be published in the paper, is that correct?
Yeah, well, first of all, there will be a published notice before the hearing, legislative hearings coming, and that will contain the location of the route. Second, if they're getting on your property, we're going to have to talk to you about an easement, so they'll be coming out to talk to you. I don't really see any way that this can sneak up on you if they need to get on your property or anything.
Well, I'm not located on the property on a daily basis, so it'll be really hard for them to approach me.
Yeah, well, hopefully they have some way of getting a hold of you.
But no, again, because of the issues with Highway 218, we're going to be going 2 miles east on the state line and then drop down on Glass Avenue and come all the way south.
Right, I understand, but I was just wondering if for some reason that route was to change back to the pink one
Right
on the map.
now, there is no foreseen.
Right, but if there was, is there a function where you have to actually
Well,
notify the
we'd
people
have to-
that would actually affect?
We basically, in the permit that we have to ask for, all of that route would have to be shown. It's published, isn't it, twice in the paper?
Yes.
So, I mean, there would be plenty of notification that we don't foresee any of that.
Of course, I'm one of the people that reads these legal notices because I know what kind of stuff can be in there. A lot of people don't. But like I said, if they need to get on your property, they're going to need an easement from you. And I certainly hope they ain't wait until the hearing before they start contacting affected landowners and getting everything lined up.
The other thing of it is that because the county is involved, we're also dealing with the voters. And so we do want this thing to be to where you're happy and the county both is happy. We're not going to try to push something down your throat. And because, like you say, that we have to have this thing working for years to come. Absolute is the same way. They have many stockholders here in Mitchell County. They also have to live here in Mitchell County, and a lot of those stockholders in Worth County too. So we're not interested in trying to push something, ram something down anybody's throat. We're interested in trying to come up with a workable project that you folks can live with, what we can live with. And we do need the gas. And so that's where we're coming from.
I do have it. Can you explain the distance on that easement that they're gonna need, like coming down the ditch? Where does that footing start from? Does it start from the middle of the road or in the middle of the ditch? Or is that a question? We got to go further.
I couldn't. I mean, right now I can't answer that.
Okay. To be honest, it varies. It varies from location to location, and easements aren't uniform, or the easement itself isn't uniform. It's going to vary on. If you take all the roads in the state, it varies from the interstate and state roads to U.S. highways to county highways. County highways will have a fairly standard easement. It gets measured from the middle of the road. But even that, you can't say uniformly that every county highway has a 33-foot or 40-foot easement from the middle of the road.
How can we find out where they can be from on our property?
Well, if I can just answer, the 50-foot is a pretty standard right-of-way width for pipeline. Now, if they're putting in the road ditch, they may not actually need to get 50 feet onto your property. They may not need to get onto your property at all, past the right-of-way line.
Okay.
But I think they're talking about 50 feet is the normal amount of room they need to build this, and how much private property they need is going to depend on a couple of other things.
Okay, that's good.
And this is what we are trying to do, is to stay off of private property, to avoid the easements, to stay in the public right-of-way. And we may have to close a road for 3, 4, 5, 6 days while we're putting that pipe, building that pipe and putting it in the ground on that road. But we're planning on trying to see if we can't work within the right-of-way and not on any of the neighbors'
I don't think anybody's going to argue with the need here. You know, it's just that where I'm concerned is what happens to me now that I know the government. I'm very skeptical.
Well, I will tell you that I drove it yesterday, and even though they want to stay on road right away, there's a few places where I think they're going to have to get off the road right away into private property. And then they'll have to deal with the landowners.
Right, that's respectful.
50-foot right-of-way plus a working right-of-way?
That's their decision if that's what they want to do. If they can.
About your 25-foot additional working right-of-way?
We've used this just as a boilerplate. That this is kind of a standard that they put in. That doesn't mean that everybody would even need near that much, but this was a standard boilerplate.
So if they're putting in a road right away and they can work off the road, that might be their work right away.
What about gas lines that are already there, as far as distance from them? If you're parallel another gas line.
You only need enough distance to avoid interference. Federal standards only, if you can within a foot of them without hurting them, that's legal.
Yes.
Now, it's my understanding that this pipeline isn't going to be put in the ditch, it's going to be put up onto the property, correct? It's not going to go right in the ditch.
It's going to be buried 30 inches into the ditch.
It's going to be in the ditch.
In the ditch, buried, covered at least 30 inches is what?
36.
Oh, 36.
It's 48 in agricultural land, 36 in public road right away.
In front of my house, I've got a nice windbreak from the north. My only concern was that they were going to come in and rip out all my trees in my windbreak, and I would be left with, no windbreak, no trees.
If
I've got, probably 100, 150 trees just in front of my house along the road, but they're not in the ditch. But they start pretty soon after
No, our intention, we had one of these issues in Worth County, and we can burrow, tunnel, whatever, and so we could, that's, again, we're going to try to work with you, not to destroy your...
Right. So if it does go, basically in the ditch, there's, it's not going to affect a lot of the farmlands and stuff like that.
It would affect possibly some drainage tile that we're going to have to be very careful on, and again, make sure that we get them all rehooked and whatever, but again, that's all part of, this whole thing is part of my district, and I'm up for re-election, and I want to get re-elected, so I'm going to try my darndest to make sure this thing is absolutely done correctly.
Because under law, the purpose of this meeting is two things. Number one, so you know what's going on. Even if it stays in the ditch and doesn't get actually onto your property. Number two, it gives you the information you need to know in case they do need to get onto your property for this. So even if right now they don't plan on getting onto your property, by having this meeting, they have the right to now approach you for getting on your property.
So is this line bigger than that one that lives on the west side of the last avenue then, or not?
Yes, this would be a, I don't know what size the line that is. We're kind of assuming it's a lower pressured line. This would be a steel line, 6-inch high pressure. That could be anywhere from 600 to 800 PSI. So
they never got off the road in the depth. The line.
I'm sorry?
I say they didn't get off the road. They never got off the road there. I mean, it was all laid in the ditch on that mile by me there. But I mean, if this would stay in the ditch, it's one thing. But if you're going across private property to get laid, it's another.
No, we're trying, like I say, we're trying to lay it in the ditch. Any place there's public right of way, we want to stay in the public right of way.
The T-connection shut-off valve says it's 75 feet south of mile. Where would that be?
Absolute energy.
Okay.
I mean, we had to try to do some rough.
Is it going to be right after 18, or would it be like on absolute energy property?
That would be right now up to.
Most likely on that.
Pardon?
Most likely on that. We're going to try and find the best spot for it.
So it'll be all right to key into this and not tell anybody. It's a lot cheaper than dry corn if you don't have to pay for it.
It's still pretty spark.
Yeah. Unless you've got a lot of experience on hot taps.
We'll be okay. We got that.
Don't do that anyway. That's a joke.
Oh, yeah.
Are you going to consider letting farmers work on it?
Basically, the answer is no. And the reason being is, again, because of the high pressure, what's required in order to put a tap in. We talked about that this noon. Probably it's in the range of a couple $100,000 at least, in order to put a tap into this line. It really gets
down. For clarification, it wouldn't be that much if it was done on the front.
Okay.
But if you came in later on, it would be extremely expensive. But it's still going to be probably cost prohibitive because of the high pressure and what's involved in running the tap. But I want to make it clear that if it was done when it was built, it was one price. But if it's done later on, it's going to be really expensive.
Compare it to the on the Alliant line with that firm taps on it. And I don't know what pressure it operates at, but just by looking at what they got, I can tell it's not a real high pressure. This line, to control the pressure off the pressure this line is going to run at, takes a lot more and a lot more expensive equipment to cut that down.
And I was remiss didn't introduce Justin with Black Hills Energy, so if you've got any questions specifically on that, we're working with them to enter into a design agreement on the line. We've had a long-standing relationship with Black Hills. They've been great to work with. So if you got any technical questions afterwards, you can visit with them too.
Yes, Mary.
Is this LLC organized now? I mean, legally organized?
Yes.
The four have joined?
It is legally organized. All four have not joined at this point.
Who hasn't?
So the two counties still have to take action, and Osage Municipal still has to take action. But the filing's been made with the Secretary of State, so it actually exists.
But before you go forward, the other three will have to join?
Yes.
So we're going to be guaranteed they're going to stay in the right of way. Because when power poles came through here a couple of years ago, they didn't even come close to following the right of ways. Quite a few problems there. I think that's what concerns myself and I think a few other people in the right of way. That got out of hand that time.
My understanding
Because back then, if they didn't have the driveway down, they just used ours and then took whatever.
No, my understanding is that basically right now, we're trying to do a number of things at the same period of time. One of the things that we are doing is, like Rick mentioned, is we are trying to work with Black Hills Energy to come up with a design. And so with the design, they will have to do the engineering, and at that time, if for some reason they feel that they cannot stay in the right-of-way, we would have to be contacting you for an easement, because we could not just come on your property.
Well, I know back then, they kind of went where they wanted to.
No, we would have to be contacting you before we ever, we'd have to work out all the details, I'm sure, before we can, like you say, or try to come very close to working out as much as we can before we apply for a permit. The other thing that I failed to mention here earlier is part of what we are doing is we're trying to do a cost analysis, and it very well could be that the costs are going to be prohibitive, that even though we've formed this company, even though we've spent the money on a design and that, we may decide not to go forward. There's no guarantee yet that we're going to go forward on this until we get all of the information on what we believe our costs are, what we might have for a little variation of costs, overruns, and this and that. And then it's decision time for all four entities to get together and decide, do we want to sign the bottom line. And so that's really where we're at. I mean, there's no, like I say, we're not, we don't know yet if we want to go ahead with it. So, but we've got to try to get as much information gathered, and so by doing that, we have to hold these meetings and start somewhere.
Oh, and follow up on something you said. It does happen that during construction, you're going along and you hit something and you got to get onto private property you didn't expect. They, you know, you may have to get additional easements as the project goes along, and there's nothing wrong with that, but they would need an easement to get on the
As long as
property.
we're contacted, that's the main thing. I mean, that's.
But just because they get the permit and everything else and they didn't get an easement from you, doesn't mean that something couldn't still happen if things, you know, change.
And if we do ever come on your property, we do have the responsibility of returning it the best we can to exactly the same state that it was before we came on it. So,
I guess I have a question for Jason from Black Hills Energy. What would be the estimated cost for 36 miles of high pressure gas line like this? You've had experience in installing it. What kind of numbers are we looking at?
We haven't come up with an estimated price yet. First, we have to come up with an agreement to put together a design. Once we get that design, if the group decides to hire Black Hills Energy or whoever they decide to hire to do that design, that will determine the price. So they have to go and do a lot of surveying, the process. There's a lot to go in before we can even come up with an estimate on the price.
Okay. Does the county have a compensation board? Because it mentioned that in there. I just wondered if the county had one, or is that something you'd have to put in place if you go forward?
both counties, I'm sure, have a compensation board that we appoint every year. And I know we just have recently done that again. That's a standing, there's so many people from the city, so many people rural and so forth that, so yes, we have. We will be sticking around after this if you have individual questions. If there are landowners that it appears that we would need an easement from, we would be glad to initially visit with you yet this afternoon. Otherwise, like I say, if nobody else has another question, we will stick around here and try to answer the best we can and go from there.
Yeah, well, if we're done with questions, I have this stock little legal phrase I need to read to close the meeting. So if there are no further questions, I'm going to say that the requirements of Iowa Code Section 479.5 have been satisfied by the presentation and discussion just completed. The company may now legally negotiate with you for an easement or other property interest. And with that, this meeting is adjourned.